today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the yeas and nays are ordered. I'd like to remind members that we've established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I would also ask all members, both those in person and those appearing remotely, to mute your microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 8227, the Speak Out Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 8227, to limit the judicial enforceability of...
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.R. 8227, the Speak Out Act, empowers survivors of sexual misconduct by ensuring that they are not subject to non-disclosure and non-disparagement clauses unless they agree to them after a dispute arises. Non-disclosure and non-disparagement clauses are often buried in the fine print of routine contracts that workers and consumers sign as a condition of employment or for goods and services. These are not the sorts of contracts entered into by parties of equal bargaining power. They are contracts of adhesion, forced upon someone who simply wants a job or wants to buy a run-of-the-mill consumer product. And these confidentiality clauses, which most people do not even know they are agreeing to, have contributed to the culture of silence in cases involving sexual misconduct, enabling sexual predators to evade accountability by silencing survivors through intimidation. In many cases, survivors are terrified to tell their stories due to fear that they will be retaliated against or worse. For example, former Hollywood producer Harvey Weinstein, currently serving a 23-year sentence for criminal sexual acts and rape, relied heavily on NDAs to allow his decades of predatory behavior in the film industry to go unchecked. Employment contracts at the Weinstein Company included strict NDAs, which prevented survivors from coming forward with their stories. Combined with aggressive clauses and settlements with the women he assaulted that, according to one of his former assistants, prevented employees from speaking to anybody, friends, family, press, public, private, about the alleged behavior, but also about their time at Miramax, Mr. Weinstein was allowed to abuse dozens, if not hundreds of women before he was finally brought to justice. The confidential nature of these clauses makes it extremely difficult to fully diagnose the scope of this problem. However, it is estimated that more than one-third of workers in the United States are required to sign a non-disclosure agreement in their employment contracts. This is particularly concerning due to the rampant nature of sexual abuse in the workplace. An estimated 81% of women and 43% of men will experience sexual harassment in their lifetimes, and 54% of women report being subjected to unwanted sexual activity while in the workplace. These numbers are appalling, but they do not tell the full story. We know that there is significantly more abuse that occurs that is simply never reported. Today, we will take an important step towards fixing this problem by banning the enforcement of pre-dispute, non-disclosure, non-disparagement clauses in cases involving sexual harassment and assault. This legislation continues the committee's important work to protect the rights of survivors to come forward and hold perpetrators accountable for abuse. Last year, in a hearing that none of us will forget, the committee heard from 4 survivors of horrific workplace sexual harassment and assault who had their right to a jury trial taken away by forced arbitration clauses buried in their employment contracts. As they explained, after enduring horrific abuse at the hands of their perpetrators, they had to experience further trauma when they sought to hold their assailants accountable in court and found that they were forced into an arbitration process that was stacked against them. Their arbitration clauses were also combined with confidentiality clauses that prevented them and other survivors from reporting and publicly disclosing their abuse. In response, we enacted the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which gives survivors a choice of whether to resolve their disputes in court or through arbitration. This legislation passed the House with a strong bipartisan vote of 335 to 97 and passed the Senate unanimously. It was an example of how Congress can and should function. We worked together across the aisle to identify a problem, establish a bipartisan solution to that problem, and pass legislation to restore the rights of millions of Americans to their day in court. H.R. 8227 is an opportunity to work together again in a bipartisan fashion to end the shameful culture of silence for cases involving sexual misconduct, promote transparency and accountability, and make the workplace safer for everyone. This legislation is supported by a broad coalition of public interest organizations, including the American Association for Justice, the National Alliance to End Sexual Violence, Ralliance, the Army of Survivors, the National Domestic Violence Hotline, and the National Coalition Against Sexual Assault. I thank my colleagues, Representatives Frankel, Buck, Cicilline, Jayapal, Griffith, Bustos, and Owens, for their leadership on this issue, and I urge my colleagues to support this bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This bill is a misguided approach to solving the problem of confidentiality agreements for victims of sexual assault and harassment. Of course, no one should be subject to harassment or assault. Victims of harassment or assault should be able to get justice. But this legislation is truly a one-size-fits-all approach that is ill-suited to address these issues. The enforceability of confidentiality agreements traditionally falls to the states, so this bill raises important questions of federalism and the proper exercise of federal power. Some states are already legislating on confidentiality or considering whether to restrict how non-disclosure agreements work. In addition, this piece of legislation is not well drafted. For example, though the bill is intended to affect only, quote, pre-dispute agreements, that's not how it applies. As drafted, some post-dispute agreements victims agree to after the dispute may be unenforceable under the legislation. Exactly where the pre-dispute line gets drawn matters as well. If only agreements that follow lawsuits are enforceable, victims may be forced to sue to get the kind of settlement they'd like. It's not clear that going to court is always best for all victims. We heard from very brave women last year in our committee, but not everyone wants to share their experiences publicly. When victims would rather not go public, it seems wrong to force them to bring claims in court to get the kind of settlement that they'd like. There are also serious concerns about the bill's scope. For example, because it applies to claims filed after enactment, it could retroactively upset existing settlements. This is a major problem. I look forward to a robust discussion as we think about what is best for the victims and for the American people, and yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. I will now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 8227, offered by Mr. Nadler of New York.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. This amendment makes two minor changes to the bill. It removes the findings section and adds the current year to the bill's short title. Otherwise, it makes no substantive changes to the bill. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purposes Mr. Cicilline seek recognition?
I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, thank you for holding today's markup of H.R. 8227, the Speak Out Act, which would prevent the enforcement of pre-dispute non-disclosure agreements, or NDAs, in disputes relating to sexual harassment and sexual assault. It is unthinkable that widespread sexual misconduct can be covered up and swept under the rug because of NDAs snuck into take-it-or-leave-it contracts. And it's unconscionable that millions of people fear risking their livelihood for speaking out about their sexual predators. This bill is simple. It will ensure that any survivor who wants to share their story can, and I'm proud to support it as an original co-sponsor. H.R. 8227 does so by prohibiting the enforcement of confidentiality and non-disparagement clauses in everyday contracts which silence survivors before a legal dispute even arises. In doing so, this bipartisan legislation will bring sunlight and transparency. It will make our society more just, and it will help end the culture of silence that allows sexual predators to evade accountability. I'd like to thank my colleagues, Representative Frankel, Buck, Jayapal, Bustos, and Griffith, for their leadership on this issue. Your hard work has brought back the constitutional right of millions of Americans and restored the voices of countless survivors of sexual harassment and assault. This legislation is important and it's a particularly important complement to H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which we enacted earlier this year. It's another step in our critical work to eliminate the culture of silence that prevents survivors of sexual misconduct from having their voices heard and thereby allows abusers to continue. But I'm a little bit confused and frankly disturbed by the opposition from the ranking member to this legislation. During last year's consideration of H.R. 4445, my colleagues on both sides of the aisle recognized the importance of preventing abusers from hiding behind NDAs and urged the committee to act and help protect survivors from this abusive practice. In fact, when we were considering the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, many of my Republican colleagues and their witnesses discussed or endorsed reforms that are embodied in the bill that we're considering today. Mr. Issa, in a long line of questions for one of our committee's witnesses, was also a survivor of sexual assault, asked repeatedly if it would be an improvement to the status quo if, and I quote, non-disclosures were taken out of the binding arbitration process in the case of assaults, end quote. And when he turned to Ms. Marshall Perry, a Republican witness, she testified that preventing NDAs in cases of sexual assault and harassment would, quote, solve the problem. In a criticism of Representative Busso's bill on the House floor, Ms. Fishbach pointed out the need for separate action to address the silencing of sexual harassment and assault claims, noting that even outside of forced arbitration, I quote, it is still possible that separate contract provisions could be used to impose confidentiality or keep details about an employer under wraps, end quote. And Ranking Member Jordan also asked Ms. Marshall Perry whether we can fix arbitration by, quote, getting rid of or dealing with non-disclosure, confidentiality, end quote. And after she made it clear that she did believe that confidentiality clauses and NDAs are, quote, precisely the problem that we're dealing with, end quote, Mr. Jordan responded, and I quote him here, yup. Later on the House floor, Mr. Jordan made it clear he supports the goals of this legislation by saying, and I quote, victims of sexual assault and sexual harassment must always have their claims heard. They must never be silenced or intimidated into silence, end quote. Why then does the ranking member oppose legislation that simply makes sure survivors cannot be silenced before they have a chance to make their experiences public? It's incredibly disappointing that we cannot agree on this committee in a bipartisan way on a bill that simply allows survivors of sexual trauma to tell their stories. I hope that all my colleagues on this committee will remember what they said last year and join me in voting for this common sense, necessary legislation. And I thank you again, Mr. Chairman, for your leadership. I thank my colleagues for being in the hearing room today, and I yield back.
Gentleman yields back. For our purposes, Mr. Buck, seek recognition.
I have an amendment at the desk.
Clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Buck of Colorado.
The amendment will be considered as read, and the gentleman will have 5 minutes to explain his amendment.
It won't take me nearly that long, Mr. Chair. It is a very short amendment, and all it does is make sure that we are protecting trade secrets and proprietary information. And really, I think it's self-explanatory and doesn't require any further explanation. So I hope my friend withdraws his objection to this very straightforward motion or amendment. And I yield back.
Does the gentleman insist on his point of order?
I withdraw my point of order, Mr. Chairman.
Point of order is withdrawn. I recognize myself in support of the amendment. I support the amendment of my colleague from Colorado, Subcommittee Ranking Member Buck, which would simply clarify that nothing in the bill would prevent companies from protecting their trade secrets through non-disclosure agreements. Doing so is consistent with the original purpose of these clauses to protect complex and valuable trade secrets and does not weaken the application of the bill or unduly narrow its scope. I thank the gentleman for offering the amendment, and I urge my colleagues to vote yes. Is there any further discussion on the amendment? For what purpose does gentlelady seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I, too, rise in support of this amendment. The NDAs were originally intended to be used as a way for companies to protect trade secrets and proprietary information, not to cover up sexual abuse. However, their expansive use now is putting all Americans at risk by keeping secret predatory behavior and allowing it to flourish. So while this is a very well-intended and appropriate amendment, I rise in support of the underlying bill. It is well past time for Congress to end the abusive practice of silencing victims. NDAs make it possible for companies to silence survivors while allowing predators of abuse to continue abusing. Allowing survivors to speak if they so choose will end the perpetuation of abuse. The bill does not invalidate any contract, but rather only enjoins the judicial enforceability of a certain provision within a contract in the event that a survivor wants to speak freely about what happened to him or her. The bill preserves state laws, protects the state's rights to pass different or broader laws as fitting, and it only applies to pre-dispute, giving survivors the choice to enter into NDAs as part of a settlement agreement if they wish to retain that right. In recent years, a slew of media reports exposed sexual assault and harassment among some of the country's most powerful companies and men, including Hollywood mogul Harvey Weinstein, Bill Cosby, Fox CEO Roger Ailes, Bill O'Reilly, R. Kelly, the list goes on, who used NDAs and confidential settlements to cover up sexual assault. We want women, survivors of sexual assault and harassment, to have the right to speak out, to tell their stories, most importantly, because they want to work and be free of sexual assault and harassment, not to allow perpetrators to perpetuate their ambitions while others lose their careers, lose their peace of mind, and worse. I rise in support of the amendment. More importantly, I rise in support of the bill, and I yield back.
Gentlelady yields back. Who else seeks recognition? For what purposes does Mr. Gates seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. And I have some concerns about this legislation, really because I think our committee did so much important work to create an appropriate venue and forum to resolve these disputes by getting rid of arbitration in these circumstances. And I was proud to join the majority in a multi-year effort to ensure that that got done and that reform was signed into law. But just as Ms. Cicilline pointed out, well, all the Republicans who opposed the arbitration changes said what we really need is NDA, non-disclosure agreement changes. I think one could reasonably say that the changes we made to the arbitration process absolve the need for these changes because there now is a place where you're not in some silent, constrained, I would say rigged environment for the powerful against the weak. People now have the choice. So if someone is being silenced, they're no longer being silenced because a powerful company or a powerful person got them to surrender away their right to an Article III resolution of their dispute in advance of that dispute even arising. They're being silenced by virtue of their own decision. And, what is the value of your silence if you don't have the agency and power to sell it if you so choose? And so I think that empowering people that have been through any type of awful circumstance like the proponents of the bill describe would suggest that our Article III courts are now available. That is an appropriate forum. Also,
the gentleman?
Yeah, no, I'm eager to get into a colloquy, but on a specific point that I've been thinking a lot about. So we used to not have no-fault divorce in America, and that required people who sought a divorce to plead a basis for that. And so even if there wasn't infidelity or abuse in a marriage, someone who wanted to escape that marriage would be required to plead those things. Otherwise, the dissolution of marriage would be automatically dismissed on the pleadings. Here, what I worry about is that let's assume there's some feature of your employment that you want to be able to whistleblow on, a larceny, an embezzlement of some kind. Well, if you would otherwise be constrained based on a non-disclosure agreement, but if you can somehow bootstrap other claims to a sexual harassment claim, and you can say that sexual harassment was sort of part of whatever nefarious activity you wanted to report, you could actually draw false claims of sexual harassment just for the virtue of being able to evade a non-disclosure agreement. So I'd ask the gentleman from Rhode Island if that concerns you.
Yeah, I thank you. First, I want to say thank you for your support of the prior legislation that this committee passed and the president has signed. I think it will make a tremendous difference in the lives of so many victims of sexual assault and harassment. The only thing I wanted to raise with you, and I understand your concern, is there's a whole range of activities that might occur, or that does occur in this space, but that doesn't result in litigation. It's good news now that it can't be forced into arbitration, that people have a right to go to court. But there are a number of victims, unfortunately, of this kind of activity who say, I want to be able to share my story so that other people know to be careful. Other people know, don't go work for that person, don't go work for that company. I don't intend to go to court and sue because I choose not to do that, but I want to be able to speak honestly and openly about what happened to me. This bill will ensure that they get to do that. And so I think everything doesn't result in a lawsuit. We've solved people who go to court and can no longer be forced into arbitration, and that's great. But we also want to make sure this secrecy that cloaks this activity that allows perpetrators to continue because nobody knows about it, to remove that. So I think that's why they complement each other and they're both important. And I thank the gentleman for yielding.
Would the gentleman yield?
Certainly, Mr. Chairman.
I just think the gentleman misspoke. We used to have fault divorce. Now we have no
I'm
fault
sorry.
divorce,
Yes.
not the other way around.
Yes, I'm not proficient in divorce, fortunately, but yes.
That's good.
I
We shouldn't have
appreciate-
too many divorces.
I appreciate the correction. To the gentleman from Rhode Island, I appreciate that, but I don't know that reduces the likelihood of this legislation incentivizing false allegations, right? Both things can be true, that you need to create a non-litigation forum, but at the same time, if you have to allege sexual harassment in order to evade an NDA, and you want to evade the NDA for some reason that has nothing to do with sexual harassment, I worry that still would, it just creates this bizarre incentive to allow people out of that. And I know that this
Your concern is that if you prevent an NDA from being enforced, that it's going to cause people to make up an event that didn't occur. I mean, I just don't think there's any evidence.
But a lot of people, when we only had fault divorce and not no fault divorce, people made up infidelity or abuse because that was the only way they could get the divorce.
But the point is, if someone makes a false claim, there are a number of mechanisms to make them responsible for any harm that comes from making a false claim. That exists in the law already.
I agree. I just worry that this sort of goads that a bit. And I
guess I would say on balance, I worry less about that and more about victims of sexual harassment and violence being able to honestly disclose so we can prevent further harm to more victims.
And I think what this,
The
I know I'm out of time,
the time of the gentleman has expired. For what purpose does the gentlelady from Texas seek recognition?
To strike the last word.
Gentlelady is recognized.
Let me acknowledge sponsors of this bill. Mr. Chairman, thank you. I moved to focus on certain points. I appreciate Mr. Gates' commentary because he's right. He was for the bill and advocated earlier on this legislation. Let me try to craft this in a way that hopefully will be effective in his reasoning. But first of all, let me acknowledge sponsors of this legislation, Congresswoman Frankel and Congressman Bustos. Congresswoman Frankel chairing the Democratic Women's Caucus. It's a very important statement. And to Mr. Gates, I think you view this as creating havoc. And I would argue that would not be the case. The issue is the pain of silence and what happens to someone who is victimized and has to be silenced. I would argue that is more the point than the breach of an NDA. It might be a situation where someone has to give this answer to something that is necessary in their life, a new job, some applications for a variety of things. Silence is punitive. It is punishment. And in some instances, it gives more freedom to the very perpetrators that you joined us and suggested that they should not be empowered. It gives them more power if this person continues in the workplace, for example, to continue harassing and maybe even assaulting women that are around them. Ending this would at least allow the person to be contained. It may never have to be utilized. Someone may never have to speak about it. But it can be a basis for ending this cycle of abuse. And then to be jeopardized as someone who's already been abused, to be sued by companies for breaking an NDA, the threat of legal retaliation that for a person who's already gone through the trauma of that, the costs that will come about for defending yourself and that you didn't intend to breach it, and the fact that NDAs are everyday occurrences. they're not something unusual. That means that you have the opportunity as a junior level secretary breaching an NDA without purposefulness, be subject to lawsuit, be subject to expenditures, and frankly, be in a quagmire that you don't deserve to be in. So NDAs are in settlements, they're in everywhere. Just view this as a protection that may never be used. But it is a protection necessary, I believe, not to be threatening on the part of the victim or to use it on the part of the victim, but in instances, the big person in this NDA is that large corporation. That's the entity that is a difficult obstacle to overcome. Over 1/3 of the U.S. workforce is bound by an NDA, according to Harvard Business Report. But instead of just protecting the company from the release of damaging information, these NDAs work to protect power dynamics that have effect of enabling abuses. So 1 in 3 women have faced sexual harassment in the workplace during their career. An estimated 87 to 97% of those experience sexual harassment never file a formal complaint. So these women have no voice because the system rewards those who may be their boss, their colleague, and it is a frightening reality. This legislation, the name seems to cause an activation, but what it does is suggest that you don't imprison the victim again twice. You allow them to be free when the circumstances comes, and you contain the manipulator, the harasser, the abuser, and you make a better workplace. So I ask my colleagues, I hope, Mr. Gates, because you have been supportive, I'd ask that you support this, be reminded of the mental health status of the victim as well, and people have to continue working. They have to work, provide for their families. So I ask my colleagues to support this legislation, and I support the underlying amendment. With that, Mr. Chairman, I yield back.
Gentlelady yields back. For what purposes does the gentleman from Ohio seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you. I yield to the gentleman from Colorado, Mr. Buck.
I thank the gentleman for yielding, and I just want to, my friend, the ranking member, made a point, and my friend from Florida, Mr. Gates, made a similar point about why do we need this if we have, and I'm going to use a woman as an example because I think the majority of sexual assaults and sexual harassment cases in the workplace involve women. If a woman has the right to go to court or go to arbitration, why do we need this? And I think it's, one reason is, and I'm going to give a hypothetical, if someone is harassed or assaulted in the workplace, that individual may not want to go to court, may not want to publicize. They may have a career that would be jeopardized, and they have made the decision that they don't want to jeopardize their career for the sake of exposing this publicly. But they do want to tell their coworkers, or they do want to tell people that are considering working for this company, or they do want to talk in a way in the community that would help protect others from this predator about the conduct that's going on. If it is a false statement, then there are remedies in the law to deal with the false statement. If it is a true statement, then the predator is somewhat isolated. The company is forced to deal with the issue, and this victim, survivor, has made a rational choice based on her needs, her future desires, her dreams, and the horrifying reality that she has to deal with. So I think that there is an assumption that every rape victim, every harassment victim needs to go to court in order to tell their story. I don't think a lot of people want to do that. And while as a prosecutor...
Gentleman yield. I just want to point out that the bill does not force anybody to go to court. It simply gives them the option.
And that's my point. That's my point, Mr. Chairman, that this
That's
bill.
what the bill does.
Right. Yeah, we're agreeing. What I'm saying is that the argument against this is that that a victim already has the ability to tell their story if they go to court.
Will you yield?
And I will.
So,
Can I just finish my statement and then I'll yield? I'm sorry. I'll yield.
So here's my question for the proponents of the legislation. Do the proponents of the legislation believe that the victim of sexual harassment should be allowed to sell their silence? Because one argument would be, you know what, they shouldn't be allowed to, because if they sell their silence, then maybe someone else is victimized later. But one theory of the case might be, who are we to tell someone through the force of law that they don't have the ability to sell their silence through an NDA? I'm just curious which side the proponents fall on.
Well, I'll tell you, reclaiming my time, or reclaiming the gentleman's time from Ohio, I believe, and I wouldn't use the term selling silence. I think it's, I think that post, if a lawsuit is brought or if there's an arbitration involving this issue, then I do think that a victim has the ability to enter into a non-disclosure agreement in that situation and benefit from a settlement. And that's exactly what this legislation anticipates. And I have another amendment that I will offer in a moment that clarifies that further. But I don't think that someone sells their silence before the rape or sexual harassment occurs. That's my concern. Someone that enters into a contract not knowing that there are predators in the workplace, oftentimes right out of college, they enter into it. It is a contract of adhesion. They are not offered an opportunity to negotiate something like that.
So quick follow-up. So as I understand that, you believe that someone should be able to sell their silence post a harassment event, but they shouldn't be able to sell it pre that event. What's your response to the ranking member's concern that the legislation as drafted would impact NDAs pre and post dispute?
If the gentleman will yield, I'm happy. There's nothing in the legislation that prevents settlement. What the legislation does is it empowers the survivor of that sexual abuse to make that determination. That they either are going to disclose it and sell it or not. So this simply takes away from the perpetrator the power to silence the victim.
I'm going to reclaim my time from everybody and just ask that we get back to the amendment that's at issue, if we can, and then I'm going to yield to the gentleman from Ohio.
I yield back. My time's expired.
The gentleman yields back. For what purpose does Ms. Ross seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. And I want to thank Mr. Buck for his amendment, which I support because it does not go to the heart of this bill, but it makes it clear that if there are situations that involve trade secrets or some other kind of proprietary information, that information is kept confidential. But Mr. Buck is 100% correct. These NDAs, pre-litigation, pre-dispute, are contracts of adhesion. They are power and control of businesses and corporations that don't want to accept liability for what their employees might do to each other. They also create a disincentive to have a strong, robust HR department, to review people's conduct, and to create an environment where people can do their best work. This bill is common sense. It just says we cannot have people signing away their rights to have a good workplace as a condition of employment. That isn't buying somebody's silence, as Mr. Gates is talking about. That is signing away your ability to have a decent work environment and protecting an employer who doesn't care about that work environment and has no incentive to improve it. This is a great bill. It is a bipartisan bill. I support the bill, and I also support the amendment that we're supposed to be debating right now. Thank you, and I yield back.
Gentlelady yields back. Who seeks recognition? For what purpose does Mr. Bishop seek recognition?
To speak on the amendment.
Gentleman is recognized.
There is an odd lack of symmetry in the conversation. Mr. Buck just said that if someone speaks falsely to destroy the reputation of a coworker or a supervisor, then there's recourse in the law available to the supervisor or the coworker whose reputation has been destroyed. I would say that recourse is imperfect from having dealt with it for 30 years. And often the question at the end is, where do I go to get my reputation back, even if I'm successful? But the recourse that you're content to leave that person to is the court, to go with the defamation claim in civil court. I, too, I voted for the provision to change arbitration law so that sexual harassment, sexual assault disputes cannot be made arbitrable mandatorily by an agreement ahead of the dispute. But this is a whole different animal. In this situation, you have someone who's been the genuine victim of a sexual assault or harassment can always file charges with the EEOC, always could, even if there was an agreement not to speak. Now they are not prohibited from going to civil litigation by virtue of a mandatory arbitration clause. They can go to civil court. They can always make a criminal complaint. That's always possible. The justice system is available in full now with the bill that was passed with bipartisan support concerning arbitrations. But this one eliminates from consideration the innocent person accused, the person who has a sterling reputation, who someone sets out to destroy. I can't think of a great example off the top of my head, but think of somebody like Jussie Smollett making an accusation. People do act, people do speak out with malign motives. Where is the symmetry in saying, well, that person can be left to the judicial system, but not the victim, not the alleged victim of a sexual harassment? There's endless rhetoric in the last several weeks about rights. But what we're talking about is stripping the rights from American people to decide to enter into a contract about what they will and will not make public. It's interesting, the chairman began by offering as the example Harvey Weinstein. I would suggest the problem with the Harvey Weinstein situation was not that victims were bound to non-competes or were bound to non-disclosure agreements. The problem was that liberals made him a giant. While he poisoned the culture, they thought he could do no wrong. Democrats lined up endlessly to kiss his ring. That was the problem with Harvey Weinstein, and Harvey Weinstein is an example of the reason that we need to strip the basic power to contract from every employee and every boss in every small business across the country. Holy cow. In the arbitration context, there was also this. The United States Congress had entered the field with the Federal Arbitration Act. We made an adjustment to the Federal Arbitration Act to put off limits from that disputes in the nature of sexual harassment, sexual assault. This is also a different animal from that. The Congress would be assuming from the state governments immense power over contract law. States can do this if they choose to, one by one. It would be perfectly appropriate if they choose to make those decisions to their contract law. But for the federal government to enter this area anew, take all that power not only from the American people to decide what contracts to enter into, but take also the power of contract law from the states, is a breathtaking overreach. I say again, I understand how folks regard the subject of sexual harassment, and it's been a pervasive problem. That's why we make tools available like the Civil Rights Act of 1964, Title VII, the charging process, ample litigation opportunities. But this is utterly unbalanced, and no Republican should support it at all. I yield back.
The gentleman yields back. For what purposes gentleman from California seek recognition? Gentleman is recognized.
Thank our colleagues for this healthy debate on this amendment and on this bill. Listening to my colleagues talk about contract rights, I would say, what's a public policy here we're looking at? We're looking at essentially protecting future victims, preventing future sex crimes. Shall we allow victims to be silenced by a few dollars and therefore put future victims in harm's way? When I was in the state legislature, I did a lot of work on DNA, sex crimes, statute of limitations. And what I learned was the average sexual predator attacks, hurts 8 to 10 times before that person is actually caught. So assuming statistics hold, these predators, once they're caught, already have a history of attacking individuals. You put a gag clause on these victims, and these individuals are going to continue to attack. So you got to balance public policy, contract law versus protecting women and men, children from future victimizations. In my district right now, without being specific because of a gag order, I know an individual that entered into a gag clause with a number of victims. He threatened, he cut a deal. These individuals cannot speak about their sexual offenses. This individual recently got another job in what I would call a target-rich environment. I can speculate, but I cannot talk about his crimes because there's a gag clause, a contract that says you may not speak about this. And this is what we're talking about today. Protection in the workplace, protection in public from known sexual predators. So that's the decision we're making today. Do you protect future victims from known predators, or do you uphold contract law? Thank you, Mr. Chair. I yield.
The gentleman yields back. Does anyone else seek recognition? If not, the question occurs. For what purposes, Mr. Roy, seek recognition?
I would just seek a clarification from the bill sponsors that it is my understanding that the legislation is not limited to enterprises that cross state lines, corporations that have locations in multiple states. That, for example, a business that were solely in the Commonwealth of Virginia or the state of Texas or state of California with a contract between that business or enterprise and the individual employee, that would be limited, this bill would apply to that situation, a non-interstate enterprise. Is that correct? Is that my understanding? I would just be asking any of the bill
If the
sponsors.
gentleman will yield,
Yeah, sure.
if you're asking, this act does not supersede any state law in this space. There's not a, it's on
will the
page
gentleman
2,
yield?
the top of page 2.
That's not quite accurate.
Reclaiming my time, and I might yield to the gentleman from Texas 1 second. I think, just to be clear, though, not superseding state law. I mean, the fact is, though, the bill and its primary provision applies, by my reading, with respect to a sexual assault dispute or sexual harassment dispute, no pre-dispute non-disclosure clause or pre-dispute non-disparagement clause shall be judicially enforceable in instances in which conduct is alleged to have violated federal, tribal, or state law. Meaning this is not just applying to, say, McDonald's or a massive interstate corporation. It would also be applying to any business wholly and fully located within the state of Texas that employs an employee wholly and fully located in the state of Texas with an agreement with that enterprise, which raises to me, I think, serious constitutional questions under Lopez, Morrison, Raich, dissent, and all the various sort of progeny, in my observation. I would yield to the gentleman from Texas.
Thank the gentleman. Actually, what the law says that's being proposed here is this act shall not be construed to supersede a provision of state law. If that's all it said, it would be okay. But it says that establishes, implements, or continues in effect a requirement or prohibition. In other words, if you do exactly like we say you must do in state law, this won't supersede it. But when it says in the last provision, this act shall apply with respect to a claim that is filed under federal, state, or tribal law on or after the date of the enactment of the act, it makes clear this bill, this committee, sometimes we get a little arrogant, we're saying it will apply to every state litigation that involves this process.
Right.
And and if you have a law, just like we've put here, then we won't supersede that law if it's just like we have.
Right.
But otherwise, we're stripping the states of the power to create laws. And so I have an amendment to deal with that, but that is the answer to the gentleman's question.
Well, I'd be taking my time back, and I appreciate the gentleman from Texas.
Mr. Gentleman, I don't think that's
further.
correct. If you look at the amendment in the nature of a substitute, continued applicability of state law, this act shall not be construed to supersede a provision of state law that establishes, implements, or continues in effect a requirement or prohibition except to the extent that such requirement or prohibition prevents the application of this act.
You want to yield? I'll yield to the gentleman from North Carolina.
I think Mr. Cicilline's point is, when I first read that language, I will tell you, I kind of just made a note to come back to it, but what it begs the question is, what is a requirement or prohibition? So if it doesn't supersede a provision of state law that establishes, implements, or continues in effect a requirement or prohibition, I mean, that's sort of an open-ended phrase. It doesn't say, but I think what it means is a requirement or a prohibition relating to these types of contracts. That is to say, a non-discrimination agreement on a sexual dispute point. So so the law as a whole sets a floor. You can't enforce any non-disclosure agreement concerning a sexual assault or harassment dispute. But if a state's done somehow more or done it itself, then this doesn't literally have any effect.
Reclaim it. Go ahead. I'm reclaiming my time. I'll close out my time. I'm sure we
Would
can.
the gentleman
engage
yield?
in-
Would the gentleman yield?
Well, I think I've just got 30 seconds left.
I think the gentleman.
I'm going to reclaim my time for the last 30 seconds, and we can engage in colloquy further. I agree and associate myself with the remarks from the gentleman from North Carolina, but I would stipulate further my concern about my original point, which is a slightly different version of that point, which is to the extent we even want to go down this road, we're not going down the narrow road of clearly applying it to corporations that across state lines. We're saying any business, and any business that is fully operating within the bounds of the state
now yield?
and the employees that work for that. And now I have no time left to yield back.
I'll extend the time for 2 sentences. I entirely agree with the gentleman. He's exactly right in his reading of the bill, and the bill establishes the public policy of the United States that NDAs are contracts of adhesion, whether it's under state or federal law, and should be banned entirely, and that's the purpose of the bill. And I'll yield back.
And I just add that to the record for the Supreme Court when the litigation occurs. I appreciate the chairman.
Who else seeks recognition? If no one else seeks recognition, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. The ayes obviously have it. The amendment is approved. Are there any further amendments to the amendment nature of a substitute? For all purposes, Mr. Buck seeks recognition. Mr. Buck has another amendment.
Mr. Chairman, I reserve a point of order.
A point of order is reserved. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Buck of Colorado.
Without objection, the amendment will be considered as read. The gentleman has 5 minutes to explain his amendment.
I thank the chair. Like my first amendment, Mr. Chairman, this is a clarifying amendment. We've heard concerns, particularly in the ranking member's opening statement, but from others also, that this bill could impact the ability of parties to enter into post-dispute NDAs. While I don't believe the bill as drafted would pose that problem in any way, I want to make it abundantly clear that post-dispute NDAs are not covered by this bill. My amendment also includes a clause to ensure nothing in the bill limits states' ability to legislate regarding post-dispute NDA provisions. And I at this point, would recognize the gentleman from Rhode Island if he wants to enter into a call.
Yes, I thank the gentleman. I appreciate the concerns of my colleague. To be clear, the bill only prohibits the use of NDAs before a dispute arises, which is triggered by the filing of a lawsuit under a state, federal, or tribal law. Nothing in the bill prevents parties from voluntarily agreeing to a settlement that does not include an NDA. In other words, this bill is carefully tailored to prevent sexual predators who are rich and powerful from evading scrutiny for their misconduct by buying the silence of survivors. And this concern, as you know, is not theoretical. Harvey Weinstein paid the survivors of his horrific abuse hundreds of thousands of dollars to silence them. His settlements included strict NDAs that prevented survivors from making their experience public. These clauses were drawn broadly, preventing employees from speaking to anybody, friends, family, press, public, private, about the alleged behavior, but also about their time at Miramax, according to one of Mr. Weinstein's former associates. During our hearing, Tatiana Spotswood testified that her abuser, former Affinity CEO Zia Chisti, used confidentiality clauses in her employment contract to keep multiple instances of overt sexual harassment and violent assault hidden while Ms. Spotwood's allegations were arbitrated. She testified that as the CEO of the company, he had power over my life and career, and I was anxious not to insult him or make him mad. And while she received a settlement in arbitration, his lawyers offered to give her father $1 million in addition to her arbitration award to prevent the case from becoming public. She was only able to come before the Judiciary Committee about her employer's abusive behavior and make her story public after receiving a congressional subpoena compelling her testimony. So those are two clear recent examples that strongly caution against preventing survivors from coming forward before a lawsuit is filed. Having said that, if the gentleman is willing to withdraw his amendment, we will continue to work in a bipartisan way after the markup to address his underlying concern before the bill comes to the floor.
I thank the gentleman, and I reclaim my time. At this point, I'm not going to withdraw. I will allow hopefully more debate on this issue, and if we can strengthen this amendment in some way, I'd like to see that, and then I will consider withdrawing at that point. So I yield back, Mr. Chairman.
Gentleman yields back. Who else seeks recognition?
I do.
For what purpose does Mr. Gates seek recognition?
Move to strike last word.
Gentleman is recognized.
So there's a fundamental misunderstanding about the operation of the bill and the operation of the amendment. Mr. Jordan took the position that the bill bars certain pre-dispute non-disclosure agreements. And Mr. Cicilline just said that the bill does not do that. And the misunderstanding comes with when a dispute arises, that can occur before a lawsuit is filed. I've litigated a number of these cases in private practice, and it is a fiction to say that the dispute arises at the time that somebody goes down to the courthouse and files a pleading. That has never been the case in any one of these matters that I was involved in litigating, and in almost every circumstance I'm even aware of, there are pre-litigation demands. And what the legislation does currently, and majority staff agrees with this, the sponsors of the bill agree with this, that currently the way the bill is drafted, you are robbing victims the ability to enter into a non-disclosure agreement post-dispute, but pre the filing of a lawsuit. That is, we should all agree to that. That is what the effect of the bill is. Now, the reason the Buck Amendment, I think, resolves a lot of those concerns is that it clarifies that your dispute can occur, the event of harassment can occur, and that you still have the full complement of rights after this bill would become law that you do today to enter into a non-disclosure agreement. I can't imagine the sponsor of this bill would want to go from a circumstance where today there's a window of time in this horrific series of events where someone could enter into a non-disclosure agreement and that we're taking that away from people. I don't think that's the case. So I support the Buck Amendment. I think the Buck Amendment would probably get a lot more people to support the underlying bill. And
Mr. Gates, would you
yeah, sure.
I'm trying to understand what your concern is. So if you have an individual who is a survivor of sexual harassment or sexual assault in the workplace who has not yet filed a claim and there is no NDA agreement, there is nothing in this bill that would, of course, prevent that survivor from settling a potential claim and saying, I will not sue you if you pay me X amount of money, et cetera. So there's that ability of the survivor to decide whether to disclose or not remains with the survivor.
but the ability to enter into a non-disclosure agreement.
Well, it wouldn't
is
be a
robbed from
non-disclosure,
the
it would be a
survivor.
settlement.
But the settlement agreement couldn't involve a non-disclosure agreement that would be operational.
And there is nothing in this legislation that would bar that.
I don't think that's the case, Mr. Cicilline. I think that if you look at the definitions
There's
on
nothing
page
in this
2,
legislation
section 3,
that
line
has,
13,
but
they
this
talk
is about in the example I just gave you, that's a settlement of a potential claim. There's nothing that would prevent the parties from agreeing not to discuss it once they've reached a settlement.
Mr. Cicilline, active harassment occurs. No lawsuit has been filed, but a demand has been made to resolve the dispute with money in exchange for a non-disclosure agreement. If this bill in this form were to become law, that would not be allowed. And I think that's what your colleague is sharing with you now.
Will the gentleman yield for question?
I'll yield to Mr. Gohmert.
Yeah, when this says that with respect to a sexual assault dispute or sexual harassment dispute, no pre-dispute non-disclosure or pre-dispute non-disparagement clause. So when does the dispute begin?
See,
Does that begin when you actually notify the employer that that employer has sexually harassed you? Or does it begin when the incident? I think this language is much too vague and probably should say something like before the incident giving rise to the dispute, because this is very vague and it's going to cause a lot of heartache.
I think Judge Gohmert has rightfully isolated precisely the issue. And in many areas of law, the way we mark the incident is when the facts give rise to a claim, right? When a claim arises from the event. And so I think of when the dispute begins at the time of the offending conduct, not at the time of the filing of the lawsuit. And so, again, I believe there's a high probability that this legislation is going to become law in some form. And so we offer these suggestions, and I think the Buck Amendment is offered so that
The gentleman would yield for one more
achieves that
time.
objective.
Just to be clear, in the bill that is before the committee, that question that Mr. Gohmert raised is answered in Section 3. The pre-dispute non-disclosure clause means a provision in a contract agreement agreed to before a lawsuit is filed. So that's the triggering mechanism. I think the problem with the amendment is if it included access to counsel so that the determination is made with consultation with counsel, I would have less concern about the abuse of that process.
I just feel like if we compare this experience to like the arbitration experience, the cake is not baked here. The way I felt like we were a lot further along in understanding.
Which is why I think we can work out Mr. Buck's concern if we have a little more time on this issue before it comes to the floor. But I think we basically agree, and I think it's just a question of sort of fine-tuning the language. And I've had the privilege of working with Mr. Buck on so many issues. I'm confident that we can resolve this one.
We'll try to keep an eye on him over here.
Gentleman's time has expired. Who seeks recognition? If no one else, then the question occurs on the amendment. The amendment is withdrawn. Are there any further amendments to the amendment in the nature of a substitute?
Yes, Mr. Chairman, I have an amendment at the desk.
The gentleman will, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Cicilline of Rhode
Without
Island.
objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This is a technical amendment that will insert language used in the definition of pre-dispute non-disclosure clause to Section 3.2, the definition of pre-dispute non-disparagement agreement. All this amendment will do is ensure that non-disparagement clauses, which can prevent survivors from making any negative statements about their abusers or employers, regardless of whether the statement is related to the nature of the dispute, are given the same treatment as NDAs under this law. So this is a technical amendment. I urge my colleagues to support this and yield back the balance of my time.
The gentleman yields back. Is there any discussion of this amendment? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. The ayes obviously have it. Are there any further amendments to the... Someone want to talk? I'm sorry, Mr. Gohmert. We'll withdraw the vote. Mr. Gohmert is recognized.
Thank. Yeah.
Oh, the amendment is agreed to. For what purpose does Mr. Gohmert seek recognition?
He doesn't have an amendment.
The gentleman has an amendment. The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Gohmert of Texas, page 1.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes to explain the amendment.
Thank you. This does fix a problem that makes this what should be considered unconstitutional. Although there are times I think this committee may be the smartest committee in the country. It's certainly
Point of
not
order,
true all
the
the-
gentleman in the press will note that.
It's certainly not true all of the time, and sometimes maybe it's not a majority of the time. But we cannot disregard the federal Constitution, and this bill, and I'll vote for it if we can make an amendment to fix the problem here, and that's what my amendment does. Instead of saying in which conduct is alleged to have violated federal, tribal, or state law, we've got no right as the federal government to step into state law and say, look, we're not even going to talk about a nexus to federal authority. We're just going to jump in and say, all your state laws and state lawsuits over this area, we're superseding them. Unless, of course, as it says in the next paragraph, unless, of course, you have a provision that's just what we dictated or more stringent. That's not our right. In state disputes involving state law, it's up to the states. And we should not step in and, well, it's overstep in and exceed our authority. This needs to be a good law that's not overturned down the road, that so that litigants that have been through the horrors of sexual harassment, sexual assault, don't find out that their lawsuit got overturned because this committee took authority it didn't have in state lawsuits. So if we can back up and say, look, this will only apply to conduct alleged to have violated federal or tribal law, then we're clearly within our authority. It will never be reversed on that basis that it violates the Constitution, usurps authority we don't have, and then once we make it clear, and actually I noticed under B part, it probably should say this act shall not be construed to supersede a provision of state law regarding claims under state law. But nonetheless, we have got to make clear this is not an overreach by the Federal Judiciary Committee. This is doing what we have authority to do under the Constitution. That's all my amendment does. And if the amendment is passed and accepted, I'll be able to vote for the bill. I yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. The amendment seeks to strike out the application of the bill to state law. The whole point of the bill is to preempt state law in this matter and to have a uniform law across the federal government. It's the same as the Federal Arbitration Act, which under the Interstate Commerce Clause has been upheld repeatedly, and there's no doubt that the federal government has the ability under the Interstate Commerce Clause of the Constitution to enact this law and to preempt state law, as has been repeatedly determined by the Supreme Court, for example, in upholding the Federal Arbitration Act numerous times. And this only applies, of course, if there's a direct conflict between this law and federal law and state law. I yield back. Is there any further discussion of the amendment?
Mr. Chairman.
Who seeks recognition? For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is
I,
recognized.
too, rise in opposition to the amendment. You know, what we're really debating here is powerful corporations buying the silence through settlements. and NDAs. Silence rewards predators. It's that simple. Silence rewards predators. The predator of sexual malfeasance can move jobs, change states, leave without ever being questioned for their choice to leave, but not the survivors. Even a high-powered lawyer, like the woman who testified before this body last year who suffered sexual harassment in the workplace, was forced into silence without the choice to speak out. That's just wrong. Forcing women into a situation where they may face public retaliation, stigma, and fear of legal retribution is not only dangerous, it's wrong. Like my colleague, Rep. Buck, just said, currently the predator is isolated and protected by the silence. We must empower survivors to have the choice to not only speak out, but more importantly, warn their colleagues. That's a big underlying problem here. The silence that is bought makes predators protected and colleagues not protected, leaving them vulnerable. This is giving women a choice. This is a question of force and choice. The bill does not invalidate any contract. It empowers survivors to speak freely about what happened to her, should she choose to. What women want is to be free from sexual abuse and harassment at work. It's that simple. The only way to end the cycle is to allow those who want to speak freely to do so. Those survivors who don't want to speak publicly won't. Regardless, they don't need to be legally bound to silence in perpetuity. We pray these protections are never used, but have precautions as large, powerful corporations is an important measure. This is of particular importance to women. I'm a vice chair of the Bipartisan Women's Caucus. I believe it's an important highlight the power differentials that still exist in the workplace, that still exist for women in the workplace. I was so encouraged to see similar legislation passed through the House and Senate, through the leadership of Sherry Bustos, Lois Frankel, and many, many others. Lift Our Voices is a coalition of survivors, of witnesses to workplace sexual harassment and assault. These women signed an onboarding, as they described, they signed onboarding paperwork on the first day of employment without knowing, and now live in perpetual silence, unable to share their trauma with friend, with clergy, with even family members for fear of being sued. Let me read just a short portion of the letter. The toll that is imposed silence takes on survivors is incalculable. Too often, NDAs are used to protect the predators, even while driving survivors from their jobs and chosen careers. Imagine lying to a prospective employer about the real reason you were forced to leave your job, because you would be sued for telling the truth. Imagine being unable to warn coworkers about a predator in their midst because your employment contract prohibits you from sharing any information whatsoever. We have the power today to reimagine the world that Lift Our Voices suffered and experienced. I move to submit the letter of Lift Our Voices to the record, Mr. Chairman.
Without objection.
Thank you. And I thank Mr. Cicilline, Congresswoman Bustos, Congresswoman Frankel, Congresswoman Jayapal, and many others for their leadership here. And I yield back.
Will the gentleman yield for?
I will yield to you.
Thank you. Mr. Chairman, I ask unanimous consent to include in the record a letter from a coalition of public interest organizations working to protect survivors and end domestic violence led by Terry Poor, Policy Director at Ralliance, a letter from more than 200 survivors and witnesses of sexual harassment and sexual assault impacted by non-disclosure agreements, and a statement from the record from the sponsor of H.R. 8227, the Honorable Lois Frankel of Florida.
Without objection. Who seeks recognition? For what purpose does the gentleman seek recognition?
Speak to the bill.
Gentleman is recognized.
So, I may have a question for Mr. Cicilline if he's available to answer it. As I read through this and I was listening, I think most of the discussion has assumed that we're talking about non-disclosure agreements entered into in the course of employment. But as I read the language of the agreement, I don't see any such limitation. Is that right, Mr. Cicilline, that it's not limited to employment context agreements?
That's correct. It would also apply to consumer agreements, for example.
Okay, so All right, so that broadens it even considerably beyond the purview that we've actually discussed. And it's hard almost to think of the other ways in which people might enter into a non-disclosure agreement. You just gave one that is new to me.
Yeah, I mean, so there are examples of people who have, in certain environments, been exposed to sexual harassment and sexual assault that would obviously want to have the ability to make those practices known. So yes.
So does the gentleman remember the Duke lacrosse case?
Do I remember? Yes.
So are you saying that this bill should protect the ability of that accuser to accuse those people falsely of sexual assault?
Oh, of course not. Look, this bill never authorizes or condones or makes permissible false allegations against anyone.
Okay,
that remains the province of existing libel and slander laws. If someone makes a false claim, we already have a robust mechanism to pay for the harm you caused by making a false claim. This bill doesn't change that at all.
All right, so if you have a situation like the Duke lacrosse case in which those young men's reputations were all destroyed by public accusations, what you're saying is they should be left to, there should be no situation in which that should be a matter of contract law. They should, even if there's a dispute and litigation doesn't get filed before, but can't be resolved that way. The only recourse those people should have, or people in that situation, would be suing for defamation.
I don't think in that case I don't think there was any NDA. And of course, anytime someone's reputation is damaged, they have under current law the ability to file a lawsuit and seek redress and be compensated for the harm that was caused. So nothing in this bill changes that.
So if someone is victimized by a false accusation, they should be remitted to their legal rights in court. But if someone suffers sexual abuse or assault, they should be in a favored classification. They should not be so limited, correct?
Yes, I mean, this is a pervasive problem with millions of victims of sexual harassment and sexual assault in a variety of contexts. I think we all take the position that ought not be kept secret for any reason, particularly if that individual has been forced to agree to some provisions as a condition of their employment. So yes, I mean, I think there's a big difference. We have slander and libel laws that give people a mechanism to go to court if they've been falsely accused of something they didn't do, and they can be compensated. That system works quite well.
So those
this is a particular problem.
I'll reclaim the time. So those who are victimized by false accusations are entitled to second-class citizenship.
I think they're second-class citizens. Our court system provides a robust ability to go to court, sue, and be compensated for all the harms that were caused as a result of a false accusation being made against you.
But the court system prior to this bill also provides that robust protection to victims of sexual assault.
Except if there's a non-disclosure agreement that prevents them from talking about it.
It doesn't keep them from going to court, just like the
going
person
to court
whose
and saying
reputation's been
nothing.
destroyed.
Going to court and then
All right,
basically...
I'll reclaim my time. I'll reclaim my time.
I don't blame you for reclaiming it.
No,
I don't want to hear the answer.
I just don't think talking over each other helps.
Okay, well then if you'll just let me finish the answer. It's like you go into court but requiring that your mouth have a piece of tape over it.
Chairman,
But you don't.
order.
I'll reclaim
Gentleman
it.
from
I
North
thank Mr.
Carolina's
Cicilline for the colloquy. I've got a few seconds left. Let me finish it. I think that's exactly the lack of symmetry that I am concerned about. Yes, people who are victimized by sexual assault and harassment suffer horrendous injury and they need to have full recourse. That's why we agreed to the change to the Federal Arbitration Act so that they can have full recourse to robust litigation. People whose reputations are unjustly destroyed by false accusations, like the Duke lacrosse players, they also are horribly injured, and they have rights to a robust litigation system. In that case, the claim is defamation or slander. But I see no justice in making one class of victims specially protected and the other class specially victimized. Why that's okay to everybody on the other side, I don't know, unless you believe all women. That is to say, if a woman makes a complaint, that is the last word. I don't think that's what justice requires. It requires an adversary system in which each side is heard and a jury of peers come to a conclusion. That's the American system of justice. I yield back.
Gentleman yields back. Who else seeks recognition? What purposes?
I move the strike, Mr. Chairman.
What purpose does Mr. Jones seek recognition?
In reflecting on the legislation before this committee
Does the gentleman strike the last word?
Yes. All right, Mr. Chairman, I
Gentleman
actually
is
moved the
recognized
strike
for
before.
5 minutes.
In reflecting on the legislation before this committee today, I am reminded of the words of women's rights activist Tarana Burke, who hails from my home state of New York. Ms. Burke is perhaps best known as the woman responsible for beginning the Me Too movement. She first did so back in 2006 as a rallying cry to let survivors of sexual violence and harassment know that there was strength in their numbers. When the Me Too movement finally swept the nation in 2017, Ms. Burke used her newfound spotlight to deliver the following call to action. Quote, "There has to be a shift in culture. We have to have a conversation about the systems that are in place that allow sexual violence to flourish. Our goal is not to take down individuals. It's to dismantle the systems that give them cover." Today, this committee is doing precisely that. We are heeding Ms. Burke's call for systemic change by dismantling a key legal tool that sexual harassers and sexual abusers in the workplace have hid behind for decades. This right here is what progress looks like, and I am damn proud to vote for this bill today. Workplace sexual harassment is an experience that is universal to both women and men. According to the National Sexual Assault Resource Center, 1 in 7 women and 1 in 17 men have sought a new job assignment, changed jobs, or quit a job because of sexual harassment or sexual assault by their employer. This scourge of workplace sexual violence and assault is not just an issue that plagues movie stars and TV personalities. The everyday victims of workplace sexual assault are our neighbors, our friends, and our family members. No one is immune. In New York, a 2019 study found that 1 in 8 working women and nearly 1 in 10 working men reported experiencing quid pro quo sexual harassment in the workplace, a brand of abuse where a victim's hiring, workflow, or opportunities for promotion are based on that victim's tolerance of another employee's sexual advances. This abuse is also intersectional, as this same study found that Black and brown employees were almost twice as likely to experience quid pro quo sexual harassment as their white peers. Other research paints an alarming picture for LGBTQ+ workers, as studies show that as many as 68% of these individuals have experienced sexual harassment or assault in the workplace. Even worse, only a small minority of these same workers ever reported these allegations to their employer. This culture of silence surrounding sexual assault and sexual harassment claims, facilitated by the enforcement of pre-dispute non-disclosure agreements and clauses, has driven countless workers from their jobs while allowing those who preyed upon them to remain unaccountable. The Speak Out Act would correct this injustice. If this bill were enacted in the years before the advent of the Me Too movement, imagine all the victims Congress would have saved from the Harvey Weinsteins, Bill Cosbys, and Donald Trumps of this world. It has been 5 years since the Me Too movement came to the forefront of American politics, and it is high time for this Congress to take definitive action to meet this moment. We began this process earlier this year when we passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, and I wholeheartedly supported that long overdue legislation. Going forward, I encourage my colleagues to come to the table to discuss whether the same type of action can also be used to curb the enforcement of pre-dispute NDA clauses for workplace abuse and harassment based on race, gender identity, and sexual orientation. But for now, to the victims of workplace sexual harassment and assault, I say to you that your stories matter, that you matter, that Congress cares, and that we will do everything we can to help you, and that we hear you. Before yielding back, I realize I've got a few seconds left. Mr. Cicilline, would you like for me to yield time to you so that you can help educate one of our colleagues about what actually happens in the courtroom under these NDA clauses?
I thank the gentleman for yielding, and I just was trying to make the point that if you have an NDA that prohibits you from discussing the conduct at issue, your ability to go to court is precluded. You can go to court, but it's as if you have a big piece of masking tape over your mouth, because speaking about the violence that was committed against you would be a violation of the NDA. So it's, you get to go to a courtroom, but you get to say nothing. So it's the likelihood you'd have any remedy is non-existent. And if I just may ask unanimous consent to include in the record a statement from Congresswoman Sheila Jackson Lee of Texas in support of this legislation.
Without objection.
I yield back,
Gentleman's
Mr. Chairman.
time has expired. Who seeks recognition?
Mr. Chairman,
The gentleman from Kentucky seeks
Move
recognition.
to strike the last word.
Gentleman is recognized.
I'd like to yield time to Mr. Bishop from North Carolina.
I thank the gentleman from Kentucky. Mr. Cicilline, are you saying that you believe that if there's an NDA, a non-disclosure agreement, and then there's a sexual assault or harassment, and the victim files a lawsuit, that if then that when that victim goes to court for trial or appears for a deposition, that the NDA prevents them from testifying about the event? Is that what you're saying to this committee?
It prevents them from speaking to friends, family, the press, to discuss or disclose the contents of the lawsuit.
Well, Mr. Cicilline, you're aware, aren't you, that gag orders are used constantly to prohibit the use of extrajudicial publicity to affect an ongoing judicial
We're talking
proceeding.
about victim advocates, for example. This would prevent a victim of sexual assault from speaking to victim advocates in connection with that litigation. So I don't think that sort of silencing is appropriate, nor do I think most members of this committee.
It wouldn't have that effect either if the victim advocate were engaged by counsel to serve the client. That would not be true, that they couldn't consult and speak freely.
Will the gentleman yield?
It's not my time. Let me just finish this one point. To the extent the implication of what Mr. Cicilline said earlier is that there be some limitation in the ability of a sexual harassment victim to litigate because they couldn't speak about the event in the course of giving evidence in that proceeding, that is dead wrong. So I don't think your subsequent discussion clarified it. What your concern is apparently is not that they'd be precluded from giving evidence, but they'd be precluded from going out and talking publicly about the lawsuit and saying what their allegations were in that context. If that's the situation, it's not unusual for people to be precluded from taking their lawsuit and then trying it in public.
Well, the
Courts
gentleman,
prevent that all the time.
will you yield for a question, Mr. Bishop?
Yes, I yield to whoever wants to go.
Thank you.
Well, it's Mr. Massey's time.
I'll yield to Mr.
Mr.
Cicilline.
Massey's time.
I think you and I have a fundamental disagreement. Are you suggesting that a non-disclosure agreement is completely vitiated by simply filing a lawsuit? Because it's not. A non-disclosure agreement precludes you or can preclude you from disclosing it to anyone. So you can't file a claim because you can't talk about it.
Reclaiming my time and yielding
That's
to
the
Mr.
whole point of a
Bishop.
non-disclosure agreement. Otherwise,
I'm yielding to
all people
Mr.
would do is
Bishop.
file a lawsuit, and then they can talk
Reclaim
about
his
it.
time.
It's Mr. Massey's time.
You certainly can seek counsel from an attorney, and
But
you
you
can
can't
file a
talk about
lawsuit,
it.
and you can give evidence. in
That
the
is
lawsuit.
not true. A non-disclosure agreement prohibits disclosure.
Will the gentleman
The
yield?
gentleman will withhold. The time is Mr. Massey's.
Who asked for? I yield the time to Mr. Gohmert from Texas.
Okay, and I do appreciate any friend on the other side of the aisle that, as was said, will educate us on what goes on in the courtroom. I've tried cases in so many different courts, federal, state, military. I've been a judge. I've handled thousands of felony cases, thousands of civil cases. I got a good idea of what goes on in the courtroom. And I appreciate the chairman pointing out, oh no, this is clearly paraphrased, not exactly, but this is what it really means. Look, we've been violating the Constitution for years, stealing states' rights, and the Supreme Court's let us get away with it. So this is certainly going to be constitutional when we steal more of the states' rights. The truth is, the Supreme Court has recently indicated, you know what? The federal government's been taking away state rights, and we're going to enforce the Constitution. But anyway, I flashback when Democrats used to say all the time, Dred Scott was decided by the Supreme Court, it's the law of the land, and you Republicans are not going to change that. Well, it got changed anyway. So I would just suggest that we have an obligation to follow the Constitution, and regardless of who's on the Supreme Court, but particularly now, because this is a matter of usurpation of states' rights. I think there's a good chance, under the current state of things, this would be struck down as a usurpation of states' rights. And I go back to my point, when somebody has suffered through sexual harassment, their life has been turned upside down, the last thing they need is to have to go all the way to the Supreme Court only to find out the Judiciary Committee got overly ambitious, thought they could disregard what the Constitution itself said, take over states' rights, throw them aside, and lose at that point because we overreached it. We shouldn't go there.
I yield back to the
Gentleman's
chairman.
time has expired. Who seeks recognition? What purpose does the gentleman from California seek recognition?
Move to strike the last word.
Gentleman is recognized.
This one's pretty easy for me, guys. Who wants a non-disclosure agreement? Sexual assaulters, people who commit sexual harassment at the workplace, sexual predators. Who does not want a non-disclosure agreement? Victims. So for some of my friends on the other side, you can come down on the side that would protect predators, or we can stand for victims. I think we'd all be better off if we stood up for victims. And I'll give you an example in this exchange between Mr. Bishop and Mr. Cicilline. If I recall, at Fox News, one of its anchors, Gretchen Carlson, experienced sexual harassment at the workplace. Under an NDA, she or anyone in a position like her would not be able to go talk to other employees who also may have been victims to try and find and stitch together a class. She would be prohibited from doing that. So whether you can go to court or not under an NDA, I'll leave that to better legal minds. But under an NDA, you would not be able to go talk to other colleagues of yours to find out if this is happening, and then in strength and numbers put together a class that could sue the corporation or the organization. And of course the benefits, as Mr. Cicilline pointed out, of having victim witness advocacy. The Duke lacrosse example, to me, frankly, is just absurd, because there are so many pathways in the courts if you are wrongfully accused through either defamation, and then frankly also if someone files a false police report, that is also a crime. So you have a civil pathway and a criminal pathway to protect against that. So to suggest that in the very small, rare exceptions where people are falsely accused, this is coming from somebody who is always, nightly, on Fox News, falsely accused, there are a number of ways, if you want to go down that road, to seek legal remedies. However, there are an overwhelming number of women in the workforce especially, and as my colleague over here pointed out, black and brown women, more so than any other class, that happens more to them infinitely than someone who is falsely accused. So to say that the false accusations is the lowest common denominator here, and we shouldn't give anyone more rights than someone who is falsely accused, is frankly absurd. So I want to thank Ms. Bustos, Ms. Frankel, and the chair for bringing this forward, because we know that more than 1/3 of all American workers are bound by non-disclosure agreements or NDAs. And these are essentially efforts to silence someone's freedom to speak about their victimhood. The states are catching up, and it's time that we catch up. In 2019, the New Jersey legislature passed a ban on NDAs for all toxic workplace issues following a high-profile sexual assault that underscored exactly how much these silencing mechanisms harm survivors. Earlier this year, my hometown, or my home state, California, and our neighboring state, Washington, enacted similar bans on NDAs and non-disparagement agreements. Several months ago, legislation was introduced in New York State to do the same. Major employers have also moved to release all of their workers for NDAs. So we're actually behind the movement here, and it's time that we catch up. The Speak Out Act is a continuation of this important work. And with that, Mr. Chair, I'm going to yield to Mr. Cicilline if he wants to put a button on any of these arguments.
I thank the gentleman for you, and I think you made the point that I attempted to make, and I thank you for offering the time.
Reclaiming my time, this bill does not impact other types of NDAs, and it does not impact any NDAs that are part of a settlement, but it does preserve state laws that go further. Because NDAs exist both within forced arbitration clauses and separate from them, this legislation is vital to ensuring survivors can speak out about what happened to them on their terms. And with that,
Would the gentleman yield?
Sure.
I appreciate gentlemen yielding. I just want to clarify something, Mr. Bishop's question to Mr. Cicilline. As a proponent of this legislation and recognizing that there are some flaws that we will fix in this legislation before it hits the floor, I want to answer Mr. Bishop's question. If a woman is harassed or assaulted in the workplace and she calls 911, she can talk to the police officer despite a non-disclosure agreement. If she seeks to go to arbitration, she can tell her story in arbitration. If she seeks to go to court, she can tell her story. Nothing in a non-disclosure agreement can prevent a victim from certain disclosures. But it certainly does, and I think Mr. Bishop would agree, prevent a victim from disclosing to others in the workplace that are outside of the legal recourse. And I appreciate the gentleman for yielding, and I yield back.
Reclaim my time and yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment. All in favor say aye. All against say no. No.
No.
In the opinion of the chair, the noes have it.
As for recorded vote.
Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson of Georgia.
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch. Ms. Bass.
No.
Ms. Bass votes no. Mr. Jeffries. Mr. Cicilline.
No.
Mr. Cicilline votes no. Mr. Swalwell.
No.
Mr. Swalwell votes no. Mr. Liu.
No.
Mr. Liu votes no. Mr. Raskin. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Ms. Demmings. Mr. Correa. Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia. Ms. Garcia votes no. Mr. Neguse. Ms. McBath.
McBath votes no.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Steen.
No.
Ms. Steen votes no. Ms. Escobar. Mr. Jones.
No.
Mr. Jones votes no. Ms. Ross.
Ross votes no.
Ms. Ross votes no. Ms. Bush.
Bush votes no.
Ms. Bush votes no. Mr. Jordan.
Yes.
Mr. Jordan votes yes. Mr. Shabbat. Aye. Mr. Shabbat votes aye. Mr. Gohmert.
Aye.
Mr. Gohmert votes aye. Mr. Issa.
Aye.
Mr. Issa votes aye. Mr. Buck. Aye. Mr. Buck votes aye. Mr. Gates. Mr. Gates votes aye. Mr. Johnson of Louisiana. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes aye. Mr. Stubbe.
Yes.
Mr. Stubbe votes yes. Mr. Tiffany. Mr. Tiffany? Mr. Tiffany? Mr. Massey?
Massey votes aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Mr. Massey? Mr. Raskin?
Mr. Raskin votes no.
Mr. Raskin votes no.
House Correa recorded.
Mr. Tiffany?
Mr. Correa, you were not recorded.
Correa votes no.
Mr. Correa
Tiffany?
votes no.
Aye.
Mr. Tiffany votes aye.
Ms. Jackson Lee? Ms. Jackson Lee? Ms. Jackson Lee on the Gohmert Amendment? Ms. Escobar?
Escobar votes no.
Ms. Escobar votes no.
Mr. Johnson of Georgia? You voted?
Mr. Chairman, how is Johnson of Georgia recorded?
Mr. Johnson, you recorded as no.
Ms. Ross? Is Ms. Ross recorded? Okay.
Ross voted no.
Are there any other members who haven't voted who wish to record their vote? Clerk will announce the result. Is Ms. Jackson Lee recorded? Ms. Jackson Lee? Would you like to be recorded?
She's giving a thumbs down.
Look at the screen.
Ms. Jackson Lee votes no.
Okay.
How will?
The clerk will announce the result.
Mr. Chairman, there are 17 ayes and 20 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in nature of a substitute? If not, the question occurs on the amendment in nature of a substitute. I don't think we've amended. As amended. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no. Appearing the chair, the ayes have it. The amendment in nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 8227 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably. A recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Dimmings? Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Steen votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones?
Aye.
Mr. Jones votes aye. Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gohmert? Mr. Gohmert votes no. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy?
No.
Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Benz?
Benz votes no.
Mr. Benz votes no. Mr. Owens?
Aye.
Mr. Owens votes aye.
Ms. Jackson Lee? Is Ms. Jackson Lee recorded? Oh, never mind, okay. Are there any other members who haven't been recorded who wish to be recorded? Clerk will report.
Mr. Chairman, there are 22 ayes and 13 noes.
The bill is agreed to. The ayes have it. The bill is amended as reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, including incorporating all adopted amendments. The staff is authorized to make technical and conforming changes. Votes have been called on the House floor, and the committee will be managing a bill on the floor immediately after those votes. Therefore, the committee will stand in recess until immediately after the conclusion of debate on the active shooter bill on the floor. The committee stands in recess.